Today marks 110 years since the 1913 Natives Land Act, which dispossessed black people of their land, was passed. The infamous legislation was also prohibited blacks from owning, leasing or acquiring land. However, the act, in fact, was later repealed back in 1991. To reflect further on land reform in South Africa to date, we're going to be joined by lawyer and author advocate Tembeka Ngcukaitobi to weigh in further. Very good afternoon to you. Thank you for joining us here on the SABC.
Thank you, Lisa. Thank you for the invitation.
So the anniversary of the Land Act, as some have dubbed it to date, obviously occurred on the 19th of June, 1913. So for context's sake, perhaps you could walk us through how the Act, according to Saul Plaatje, made the South African black not a slave, but a pariah in his own land of birth.
I think perhaps there are three major episodes that preceded the Act. The first was the sort of colonial episode, which is the arrival of Europeans, initially the Dutch and later the British, and conquered native people and took their land primarily through war, barrel of the gun. Once that process was over, the Europeans had to establish a nation. That's probably what I can refer to as the second phase. They had to establish a nation. They had to establish a country. What they did, they consolidated two republics of the Dutch and two colonies or British settler colonies, the Cape and Natal, Transvaal, as well as the Free State. Orange Free State, consolidate them into a nation. And that happened in 1910 under the South African Union Act created. Now that establishment of the country, the creation of a nation, excluded natives or Africans or black people as participants. They could not vote. They could not be voted for, and they were effectively not regarded as citizens. So a fundamental element of the establishment of this country we inhabit today as South Africa is the exclusion of Africans from the rights of citizenship. And the final nail then is the passing, which is the third. It's the passing of the Native Land Act, which defines the rights of citizens and non-citizens, citizens and natives. And that does so through the allocation of land. At the time the Act was passed, it was a 93%, 7% split. So native people, although they comprised more than 80% of the population, were only allocated 7% of the land. And Europeans, although they comprised less than 7% of the population, were allocated 93% of the land. So as a black person, you couldn't acquire the land in European areas unless you had the permission of the Governor General. There was also a similar provision for applying to Europeans, but everybody knew that Europeans had the lion's share of the land anyway. And so that's the baseline of the Act. It continued existing in that fashion until 1936.
Let me interrupt you. Let me interrupt you here, just for interest of time. I want to perhaps look at, on the back of what you echoed, given the context, and thank you for that, how we can understand the current mammoth problems that South Africa faces in relation to land reform. Perhaps you could speak to what the current challenges are to landlessness in both urban and semi-urban spaces, and also the current struggles for security of land tenure in rural South Africa.
There are three primary problems when it comes to land. The first problem is the incomplete project of land restitution. So there was an act passed in 1995 whose primary intention, in fact, I think it was the first act that Nelson Mandela signed. It's a 1994 act, but I think it was passed only in 1995, which is the Restitution of Land Rights Act. It entitled those people that could show that they were victims of forced removals under the 1913 Native Land Act to claim land. The problem has been that the promise in that act has not been fulfilled or implemented. The second problem has been a problem of security of tenure, and that is largely manifested in rural areas where, although rural people live in these areas, they don't have secure tenure because the way in which the tenure system worked under apartheid and even under the colonial period was that Africans had no right to have land in their own name as owners of the land. And so the land tended to be entrusted in white hands or under chiefs. And so there has been a lack or a failure of transforming the land tenure system. The third problem has been a basic problem of distribution. So in other words, if you are outside of this ambit of land claims under the restitution system, you were supposed to be catered for under a redistribution system, so which is a system of access to land based on need. But the problem is that it's been a catastrophe when it comes to the land redistribution. There has been no progress made, no law passed, no implementation. And in circumstances where it's been applied, it's been completely farcical. It's been overridden by corruption with public servants placing their own interests ahead of everyone else, with a lot of corruption from landowners, with a lot of corruption from land claimants, with a dysfunctional system. So the land reform process over the last 30 years, it started well, but the last 5 years have been a farce.
You and a few others have been critical of the Communal Land Tenure Bill, which is expected to be tabled in Parliament, according to the Department of Agriculture, Land Reform and Rural Development. I wonder if you could speak to that, help us understand how, in your opinion, it entrenches colonial approaches to land holding as well as administration.
Yes, I mean, it's part of this, I would say, farcical approach to land reform that this government has adopted. What it should have done when it comes to communal land is that it should have strengthened the rights of people living on the land. Right? That was the object. And that's not an object that we are advocating for. It's the promise of the Freedom Charter. The land shall belong to all those who work it. So that's the promise of the Freedom Charter. But what it has done, what the government has done, it's attempted to strengthen the rights of chiefs, rights of traditional authorities, at the expense of people that occupy the land. And so it's undermined those rights and the rights of occupiers of the land and strengthen the rights of chiefs. So the Communal Land Rights Bill continues this trajectory of entrenching chiefly authority over the land. The language that is used by the government is that it's applying and implementing customary law. But what it forgets is that it is distorting customary law because it pretends as if it's the true customary law that it is applying, when in fact it's the distorted colonial version of customary law that imposed chiefs on top of people. So the argument is that it inverts the analysis and that it puts chiefs over people, whereas it should be the other way around, where the chiefs, if they have any control, it's control over the political organization, but it's not control over the economy, which is the baseline of which is the land.
I also want to get into IPILRA, which has also come to the fore. Yes. You write in Land Matters that we ultimately need to be rethinking the meaning of land. The struggle for freedom was therefore the struggle for land. And I wonder how we can begin to undo the legacy of the Land Act in progressing land reform in South Africa, using IPILRA as a basis somewhat at this point.
Yes, for those who don't know, thank you for citing my book. I'm very pleased that at least one person other than me has read it. So IPILRA, for those who don't know, is the Interim Protection of Informal Land Rights Act. So what had happened in 1995, and most of these transitional laws were passed during that period, the ANC government thought it was necessary to pass a transitional law to protect the rights of people that were effectively living in the Bantustans. And there were 10 of these Bantustans, 4 of whom were regarded as independent, another 6 was regarded as self-governing. So they thought, let's pass a law that will protect the interests of the people living in these areas. And that was the IPILRA. And one of the provisions that it catered for was, we need to strengthen the rights that are held under custom over the land, because it identified those rights that are held under custom as being at the most possible likelihood of being taken away. So they thought these rights are vulnerable to capture, vulnerable to control. They need legal protection. That is why they passed IPILRA. Unfortunately, IPILRA was a statute that was meant to be renewed every year, and that is what has happened. It's been renewed every year. It's not been made permanent or strengthened. But it's been a very powerful instrument against chiefs, against mining companies, against the government that constantly encroaches upon land held in customary tenure systems. So it's a statutory manifestation of customarily held land. It's the only statutory enactment that protects land held through custom. Otherwise, you look at the Constitution itself, or you look at customary law that is largely unwritten.
Yeah.
So IPILRA then serves as a useful basis for the entrenchment and the protection of very vulnerable people in villages.
I want to look at where to from here, just on the back of everything you've echoed. One is to question whether there is political will to act. What are your thoughts on the ruling party's proposal to rely on land donations? What are the reform weaknesses at this point? After elective conference on the 19th of December last year, you actually looked at President Cyril Ramaphosa's speech and said that he missed crucial issues in land reform, which was part of what he faced in his first 5 years of office. How would you weigh in on those questions arising at this point in relation to the land reform debate?
Well, I mean, I think the evidence is quite clear, Elizal, isn't it, that the current administration has long taken its eyes off the ball in relation to land. It is simply disinterested, right? When it tries to act, what we usually see is discord and discoordination, right? So there is a need, either in the current configuration or in a future configuration, to return to land, right? I mean, unfortunately, land is one of those elements that is easy to forget. You know, we always remember it. Like now, it's 110 years anniversary of the Native Land Act, and I think today there's no one else talking about the Native Land Act except the two of us in this program. So it's easy to forget. I mean, I'm reminded actually of another episode, which I think I referred to in The Land Is Ours, which is that in 1914, actually, there was a delegation that went to England to protest against the Native Land Act. When they arrived in England, they were told that the issue of native land will be dealt with after the end of the war, 1918. And for now, they had to support the British in the war effort, which they agreed to. And they came back and they organized people to support the British government in the war effort against Germany in 1914. When they finished the war in 1918, they expected that the issue of land would be resuscitated. But they were disappointed. And the reason I mention this is because we are again 110 years later talking about another war. right? And that war is also occupying the space and also disabling us from talking about land, you know. So the key element, if we are to take the land debate forward, is to take land seriously. The problem with the government of the ANC is that it does not take land seriously at all. And the evidence that we have gathered in the last 30 years is that it will not take land seriously. And the people that will take the land debate seriously are grassroots institutions, are grassroots people. What we have to do as professionals is to support them, is to support grassroots, landless people in their struggle. And land also has been highly politicized. I mean, like the debate we had in the last 5 years about whether to amend the constitution or not. Again, another farcical debate which ended up in failure because it was a politicized debate and had nothing to do with the resolution of the land injustice that we face in this country. So we have to do two things. The one is to recognize that ultimately land is a question of injustice and it's continuing colonial injustice. And secondly, it's to give help to landless people that are engaged in daily struggles to return the land.
Advocate Tembeka Ngcukaitobi, thank you for joining us. There's so many more other issues we wanted to touch on, of obviously also looking at the steps where to from here, perhaps as we look at the conference that's also set to take place a little later this week. But thank you for joining us on the SABC and speaking to the issues of land reform in South Africa. This, of course, in relation to today. We'll reflect on the Natives Land Act, which was passed back in 1913, and what that had on South Africa, in a democratic South Africa, in fact, how it impacted socioeconomic conditions. Again, thank you to him for his time with us here on the SABC.